Hi everyone, this is to respond to Tuesday's Supreme Court ruling restraining or creating the provision to restrain the media from reporting on ongoing or sub judice cases. Although the Supreme Court bench led by Chief Justice Kapadia has categorically said that they will not write or order any general rules for media coverage and that this will be assessed on a case-by-case basis, it still sets extremely dangerous precedents and sends out a very uncomfortable and disturbing message. Undoubtedly, this is a very complex issue. Undeniably, the media has been egregious in many cases in the way it has reported ongoing proceedings in the court, at times being extremely prejudicial to a fair trial. A perfect example of this is the Arushi Talwar murder case, where the media has swung wildly from creating prejudgment upon the parents, at times on the servants, sensationalizing the case, creating a kind of almost public hysteria, a linchpin witch hunt mood, which has definitely made it difficult for justice to be done in that case. But to use one example of the Talwar case, or in this instance, the dispute between Sahara and SEBI, where Sahara claimed that some documents had been leaked to the media, which was prejudicial to its trial in the court, to extrapolate certain miscarriages or certain egregiousness, examples of egregiousness by the media, into something which could very, very easily become a sort of muffling of the media, is a dangerous moment in our democracy. There are many reasons why this should not happen. First of all, I'd like to give Tehelka's own examples. Tehelka's journalism has played an important role in many sub judice cases. Binayak Sen's trial was already on when Tehelka published a cover story that went a long way in clearing some of the doubts around the Binayak Sen being a big Maoist leader. This story examined the prosecution's case against Binayak, it examined the evidence and analyzed that in a factual way. The same could be said about Tehelka's path-breaking Gujarat investigation of 2007. At any point during that, when that investigation was ready, somebody being tried in the courts related to the Gujarat riots could have gone to the High Court, and a aggrieved party could have asked for a stay on Tehelka's investigation. Today, when the Naruda Patia judgment has come in and has relied heavily on Tehelka's investigation, it's a perfect example of how a very important piece of journalism could be sidetracked, could be put on cold storage, could be postponed for long durations of time if a wrong call is taken by a judge. There are many other examples I could give you. There is the story of Soni Sori, the tribal woman from Chhattisgarh, still in jail, against whom there seems to be a very flimsy and motivated case, again presenting her as a dreaded Maoist leader. There is the famous Jessica Lal murder case, where again a Tehelka sting investigation helped reopen the case and bring Manu Sharma to justice. The reason I'm going into these cases is to present the very real and imminent danger of creating an atmosphere where any aggrieved party can approach a court to stay a journalistic story. There are 2 or 3 points I'd like to make here. One, when the media oversteps the line, there already is provision for recourse. There are innumerable cases where aggrieved parties have gone to the court and got a stay on certain media reportage. A good example of where, again, this falls in a grey area is Amar Singh getting a stay on the tapes that showed him in some extremely dubious conversations. But that tape was never aired, and the media could not proceed in analyzing the evidence that was available in those tapes. My point here is that the possibility of recourse is already there, but to turn it into something normative, to make it the norm rather than the exception, is a very dangerous trend. Secondly, the assumption that right to freedom of speech is offset by the right to fair trial is a fair one. But if we assume that a judge is capable of assessing whether a story is going to be prejudicial or not, surely that judge should be immune from prejudice in the first place. One can put out the premise that a journalistic story creates a public opinion around a certain case, but surely it should not affect the judge. And if we assume that a judge is human and fallible, then can a judge not make mistakes in assessing whether a journalistic story should be done or should not? Should journalistic freedom then become contingent on the particular acumen of a judge anywhere in the country, a High Court judge, even Supreme Court judges? This is not even going to be referred to a constitutional bench, not even to the Chief Justice of the Supreme Court, but to any judge practicing anywhere in the country. Yes, there is great respect in India for the judiciary as an institution, but history and evidence shows us that judges themselves can be human. Do we want that plinth of Indian democracy, which is media freedom, to become contingent on individual assessments? We have a great example of the Karnataka High Court recently, who said during a petition by a woman who was complaining about her husband beating her, about this Karnataka High Court judge that advised her to not complain and to accept that beating. Should the media not comment on these cases? If the aggrieved husband went to the court, to a justice like this Karnataka High Court judge, will that judge's assessment of journalistic freedom be something that we want to live by? This distinction is something that we must insist upon. There should be provision for recourse, but media freedom should not be curbed under any circumstance. Thanks so much for listening.